And hello, everyone, and welcome to the Copyright 2.0 show. I love how Google Hangouts does that little tease where it's like, we're going live, we're going live, we're going. Now we're live! Thank you very much for the warning, Google Hangouts. But my name is Jonathan Bailey. I'm from the site Plagiarism Today, and on Twitter at username Plagiarism Today. And joining us, a lawyer who is not here to bring you legal advice, but to bring you other wits, witticisms, and wisdom. I am quite sure of that. It is Evan Sherez. Evan Sherez on Twitter. How have you been, man? It's been far too long.
Yeah, I've been good. Excited to talk copyright again. And
Yeah.
as you mentioned, I'm not here to give legal advice, but so you should, don't rely on anything I say when you're going to court.
And
Sorry, go ahead.
and any guarantees of laughter are not actual guarantees. They are
Yeah,
just merely it's merely advertising puffery.
Yeah.
Um, yeah, but
We have a good show. Good show today.
Yeah, we got a great lineup today, and largely because we're helped by having so much news to choose from. We have like 3 weeks of news to go through, so we got a lot to go over. And we're actually, I'm kind of fascinated, and I'm looking forward to getting your feedback on our first story this week. We're going to be talking about the Supreme Court and the Google Oracle case. Some news there. Also, a major update in the Dish Network lawsuit. Long story short, there we've got a very interesting ruling to discuss, but also a postponement in the case, if you will. And a lot has been happening in the Marvin Gaye Blurred Lines trial. That thing has just been reaching crazy factor 11. We'll be talking about that. Now we have more people getting lawsued over pre-1972 music. Who's on that list? You'll find out in a minute. CSAC, the lesser known of the performing rights agencies. You know, the one everyone forgets to mention whenever they're listing them. Huh?
Yeah, it's they definitely get lost and it's because they're not subject to the same decrees, and which is what brings us to our story.
Today, yeah. I love going into bars and going, okay, there's the BMI sticker, there's the ASCAP, where's CSAC? You need CSAC too.
And there's going to be global rights, global music rights is going to have to be there too.
There's going to be a fourth sticker to put on your little mirror bars, I'm just telling you. It's coming. It's coming. Then we've got Beastie Boys wanting a little bit more money, a bit more money out of their lawsuit. Also, the Sam Smith, Tom Petty suit will have, not lawsuit, the dispute, my apologies. We'll have a breakdown of that. And also an update from Norway where music piracy has apparently gone the way of ice giants. And just saying. Hey, it was part of the theology, right?
Well, let's say gone the way of something that actually existed, so that we can jump on, right? By anyone who's trying to, interpret that.
The Seahawks Super Bowl hopes.
Oh, there we go.
Too soon. Too soon. I'm going to get some letters about that one. Okay.
That's for sure. Maybe some takedown requests for this show being too offensive.
Speaking of which, did you watch the Super Bowl?
I did watch the Super Bowl. I had the pleasure of being invited to a Super Bowl party where the food was fantastic, and the best part is I got to take home like a nice goodie bag of steak and treats, and it was amazing. And the game was also obviously, one for the ages. I mean, who throws the ball at the 1 yard line on first down? It's so stupid,
Well, it was really funny. It was really funny. I didn't watch the game, but I found out about the ending pretty quickly, and I told my significant others who may not be the most football literate people on the planet about it, and said, they were on the 1 yard line, and then they passed, and everyone's like, "That's the stupidest thing I've ever heard." It's like, yeah, okay, non-football audience gets it too. Got it. So yeah, no one seems to think that was a good idea. No one. Yeah. And interesting. Have you seen the meme based upon the Northwestern insurance commercial? The really depressing commercial that they aired.
Yeah. The kid who died.
Yeah.
I saw that. My roommate, who's a bit of a Twitter celebrity with 20,000 followers, tweeted out a meme with it was that little kid, and he's like, I would have survived, except my parents didn't believe in vaccinations. Kind of jumping on both bandwagons at once.
That's well. There was a meme going around saying I would have run it in from the 1 yard line, but I died.
But I died.
And the guy that actually created that, his name's Jared Smith. I know him through a friend, and B, the previous co-host of the show, Patrick O'Keefe. So small universe here, small internet. I am like 3 degrees away from the guy that created that meme, so it's pretty
Yeah.
amusing.
I also predicted that the Sharks would be like the hit of the Super
I
Bowl.
mean, he totally was.
Impact. I jumped on that right away. I put
You
a
might
little
say you
Facebook
jumped the
status about.
shark.
I put a little Facebook status like right as it was coming up, like confirming that I was Shark number 2, and that was a hit amongst my friends. And
You were left shark? Is that
I was
are
left
you
shark,
confirming
yeah.
or denying the proof that you were left shark, Evan?
I am confirming that I was in fact left Shark.
Oh, well, that's too bad because I was right shark. I actually remember the moves.
Yeah.
I feel bad for left shark though. No, who can dance in that? Really? That's
I
like
think
the
he was.
worst. That is the worst costume in history for dancing. And I'm just saying, I feel bad for left shark. I have no animosity. But yeah, we got we do have a lot of great.
Jump into the show, yeah.
Well, we do have a lot of great copyright news. Do you want to dive on in and start talking about the Supreme Court and the wonderful photo on this article on Ars Technica, which looks like it was taken at a senior citizen's home?
Right. So the Supreme Court asks the Department of Justice, which is the Obama administration, to weigh in on the Google Oracle API copyright lawsuit, which on appeal the decision was reversed, and basically the appeals court said that these APIs, or a certain part of these APIs, are in fact copyrightable. So you may be asking, what is an API? Well, that's a really good question because a lot of people have a difficult time explaining what an API is, and without even getting into the technical details of what they alleged was copyrightable inside the API. So when they have to explain this to the Supreme Court, I'm excited for oral arguments, and I think I've said that to you before because, it's a technical topic. So an API is something that lets two different programs that may be written in different code to communicate with each other. So when your phone has downloaded an app that is trying to connect to, let's say, your TV, but your TV was, let's say made 3 years ago, and this is written in a new language, but you still want to get your photos on your TV, APIs are how these two things communicate with each other. And so, basically, Java, made by Oracle, has really dominated the market for APIs, so that, you really, they're really the go-to people when it comes to how APIs are written.
Mm-hmm.
And so Google, when they were basically writing their own APIs, used a lot of the language that these Oracle APIs had written. And so even down to the headings, which are not necessary, according to Oracle, but Google says that, hey, the way you wrote these is the way it has to work. There's no other way that we can do this because it's utilitarian, which is a big exception in copyright, which is that if something needs to be there for a utilitarian purpose, like, for example, if a chair has 2 arms, you can't claim to have a copyright on a chair with 2 arms. Well, that's where I gotta put my hands.
A good example in writing would be actually a lot of legal writing falls underneath this. If there's only one way to testify or declare something, that method of declaring it is not going to be copyrighted. You cannot sue the lawyer that comes behind you and uses that verbiage.
Right. Although a lot of copyright trolls do try to do lawsuits. Sue law firms on their on the boilerplate contract language, but yeah, that's a good example of it. Certain things, if they must be there in order for something to operate, cannot generally be copyrighted. And so, the way these APIs function is allegedly utilitarian, according to Google, which is trying to say that hey, we could really use this if we want to, because you can't protect this, otherwise the whole internet as we know it, might fall apart. And so what's happened here is that certiorari has been granted, which means that it's going to go before the Supreme Court. And
I thought cert had not been granted yet.
um,
I thought it had not been granted yet. That they were debating whether or not to grant cert.
I thought certiorari was granted, but that's just what my notes say here. I could be wrong. I'll defer to you on that. How comfortable are you on that? We can look it up really quickly.
Yeah, we can look it up really fast.
But
I'll look
anyway,
it up. You keep talking.
I'll keep talking. So what they've done is basically ask for an amicus brief, which is a legal position on the importance of the case and who should win, depending on which part it's at. If it's at the step where they haven't granted certiorari, you're generally trying to, convince the Supreme Court that this is an extremely important case that you should hear. If it is already at the Supreme Court, you're trying to tell the Supreme Court who should win. But an amicus brief is basically from someone who's not interested in the case. It's a third party, and often the Supreme Court wants the government's point of view, so they they issue a request, and it gets into this really funny business of like how much
cert has not been granted yet.
Cert has not been granted. Okay, John 1, Evan 0.
At least not as of December 23rd, and I don't think you're going to get the Supreme Court to do much between then and now.
Yeah, so they've asked for the government's importance of deciding this case. So yeah, the government usually has about 60 days to answer and give them their opinion, although I don't think there's really a hard due date. I actually had to research this for a partner once, which was that, like, what happens if the government misses a deadline,
Nothing.
Yeah. So I guess we'll figure out.
Try being a government contractor and missing a deadline. That's different, though.
Yeah.
That's very different.
So we're gonna see if Google's copying of the names, declarations, and header lines of Java's APIs in their Android platforms is in fact copyright infringement.
And one of the reasons I thought I was pretty sure that they hadn't granted cert was because I've actually had a debate recently with several of my friends and fellow copyright legal eagle types about whether or not the Supreme Court will grant cert. I seem to think there's a decent chance they will, and the fact they're writing the DOJ seems to think they're at least taking a strong interest in the case.
Yeah, I think this is an important case that'll get granted. This is one of those areas where, like, I'm always a little hesitant to talk about because it kind of gets into that software computer science degree stuff. Well, I mean, you can talk about copyright, to a certain extent on the fringes of this case and explain the basics of, a utilitarian function. Yeah. But then when it really gets into the nitty-gritty of it, I need a computer scientist here with me.
Well, we definitely could use one on this show, at least part-time, and it's one of the more frustrating elements of this is that, I consider myself pretty tech-savvy. I find a lot of this confusing,
I think that's why they asked the DOJ. They're like, do we really have to take this? We don't want to.
You're gonna make us, and then if the DOJ snaps back saying, nah, it's not important, the Supreme Court's gonna be like, screw this, we out.
Yep.
Because seriously, go back and read this article on Ars Technica, look at the photo. That's the group of people that'd be deciding it.
Yeah.
I
think when this case is decided or when oral arguments are heard, we should have a guest CES guy on the show.
And I know who I nominate. I nominate the Chris Matthew. If you are listening to this, the first co-host and actually the founder of the Copyright 2.0 show, and a rabid software developer, has written many applications. He would be a great person to talk to about this. So, Chris Matthew, you're on notice. If this gets certain, we have to talk about oral arguments. You are coming on this show. Even if I have to kidnap you, I will go to Phoenix and kidnap you, if needed. That is a threat. Not a threat in the legal sense of the word, but in the fun, playful meaning of the word.
Right.
If there is one. Well, okay.
So let's
talk about Sling.
Gears. Yes.
Let's talk about Sling. Sling and Hopper, and how many more advertising words can we squeeze into this, you think, real fast? Dish Network has been having a long-running battle with Fox and other television networks too, but some of those seem to have been settled over various features it offers, including auto hop, which is a feature which lets you automatically skip commercials in some TV shows. Apparently, it doesn't work in all, but only like the major primetime ones. You know, the ones they invested the energy into creating the pattern for, I suppose. Um, I tried to skip the commercials in an infomercial once. That didn't work out so good. Um, just got 30 minutes of static. But and also Sling, which is a service that they provide, which lets you take the content on your DVR and
Right.
sling it, haha, to various other devices, including computers and phones and whatever else you may have you. Fox has been going at them over this. One of the issues has been a copyright issue, saying that Autopop is a copyright infringement, and that Sling is echoes of Aereo, so to speak, and is also a copyright infringement itself. It seems, however, the judge largely disagreed, and I want to point this out. The judge's name is Dolly M.G.
Interesting.
I just can't get that out of my head. Dolly M.G. I mean, I'm sure she is a very capable judge and a wonderful human being, but that is a rather strange name for a judge. You have to admit.
You know what? I'm not gonna jump on that one
You know,
because
just in case you ever have to be.
that's just bad. That's bad form.
It is. I
All I know is
apologize.
that she needs to name her daughter O, so that they can be OMG, and then that would be
Well, no,
perfect. Um,
no, she needs to marry someone with the last name Willikers, and then hyphenate the last name, so it'd be Dolly G. Willikers.
this is a face palm for those listening in the audio part only. That's what the silence is. It is a sincere face palm. So.
We should move on from that quickly.
So, I think the more interesting part of this settlement or of this lawsuit is it just gives us a really good example if you look at some of the other lawsuits that were filed in this case of how to settle a lawsuit like an adult so that you don't end up in the legal fee situations that we're going to cover in the Beastie Boys monster situation because
Foreshadow.
ABC, and CBS settled their litigation last year, agreeing to modify the ad skipping feature so that it won't be available for 3 days after the show run on ABC and for 7 days on CBS. So here we are with a reasonable compromise on what is essentially like a bad service from the content producer's standpoint, because if everyone is always able to skip ads, then their revenue source is gone, and Dish knows that. But then again, if it's 7 weeks later and I want to watch a show, first of all, your commercials may not even be relevant anymore, so why should I have to watch them?
Yeah,
And there should be some ability to do that. So here we come for with a good compromise that lets Dish, advertise this new technology, which I'm sure it had invested a lot in and patented into its clients, to gain, some more revenue, and it also lets the content producers guarantee certain numbers to their advertisers. And so that's how you should properly settle one of these instead of, doing what essentially has happened here, which is that this is, obviously probably taking a whole bunch of legal fees to get to, which is that it is not a copyright violation because there's a fundamental difference between what the Sling service does. So this we're talking about the Sling, not the ad skipper now. What the Sling service does and what Aereo did. Basically the Dish DVR automatically sent. You kind of slung, as you mentioned earlier.
Hey, I didn't name it. I'm just throwing that out.
Just like it kind of Aereo went from Aereo servers to any other media device, handheld device by the customers. This basically allowed the customers to sling their signal coming into their TVs, which they have the right to do, to a second product, which is akin to almost that time shifting that we decided was fair use in the 80s, which was you're able to kind of, if you have the right yourself to watch the television, you can kind of figure out where and when you want to watch it.
And it was interesting when Aereo ruling was handed down. There was a lot of Chicken Littles out there, like the sky is falling. No digital service will ever be able to operate in this field again. There'll be no chance to ever have innovation in technology. And then, like, not even a few months later, we had this key ruling against Sling and AutoHop that seems to, you know, make some sharp distinctions between Aereo and this. It seems like the Aereo ruling is going to wind up, though it was a Supreme Court ruling, having a very isolated impact on copyright, at least.
Well, I mean, they were essentially ruled that there was no copyright violation.
Yeah.
So if you're a subscriber, if you're already subscribing, to that authorized to the content, and you're receiving it in an authorized fashion on your own box, the subsequent transfer of the programming, by Dish Anywhere takes place after the subscriber has validly received it. So, Aereo transmitted its program to subscribers directly without a license to do so, while these people already had that right, and that was
exactly, and that's the key difference. And from a copyright standpoint, that pretty much summarizes it nicely. Mm-hmm. Now, the judge did seem to agree that there were certain potential contract issues here, kind of separate from the copyright ones, that a deal between Fox and Dish may or may not have been violated over the course of this. And also that they targeted a little bit the primetime anytime, which apparently lets you record the entire primetime programming for a network and view it, and there was a deal between them where Dish could not offer Fox Television as video on demand.
Yeah.
And that pushes that a little far. The judge seemed to agree with that. But what else is interesting is after the ruling was made, but before it was unsealed, the two sides asked for a hiatus, if you will, on the litigation, saying that they think they can reach a settlement now, and they're going to try and work it out in a way. They even though the trial was not scheduled until October, that's too soon. Let's just push it back past that. Let's take that off the calendar. And so they seem to think that they can reach a settlement now. But as you said, everyone else did it last year.
Well, we still have NBC's litigation.
That's true. So, okay, it was CBS, ABC, and who else was the other one?
Fox.
Fox. Okay.
Right.
So CBS and ABC is settled.
Yeah, so at least they didn't do as badly as I guess NBC has done in terms of this negotiation and settlement. But anyways, I think that really brings us to the point of the importance of the threat of litigation. So at one side, I talk about the importance of kind of getting things done as adult, but on the other side, you kind of need this threat and maybe this gray copyright area to bring these two sides to the table and be like, hey, this is gonna benefit nobody if you both just lock horns for a while on this kind of gray issue, come to an agreement about what you can do with this new technology, and in order to compensate content producers for potentially lost advertising revenue. So, this is a good way to look at both sides of the coin of, is copyright litigation the way to go? Should it be completely ignored? Well, this kind of brings you right to the middle of the gray area, which is that it's kind of needed for people to come together, and you can see that the general strategy of getting to an agreement first is going to cost you way less.
A very wise attorney once told me that 95% of litigation is negotiation. At the end of the day,
yeah,
that's really what it's about. A lot of times, litigation is nothing more than one side trying to gain an advantage in negotiation.
That's 100%. I think that's true. You file certain statements and motions to change your bargaining position. And
if you get a few favorable rulings from the judge, things are looking more your way. You've got that leverage with which to get better terms in negotiation. So,
speaking of lawsuits and negotiations, let's
go on
to the next story here.
Yeah.
The next saga in the Marvin Gaye and Robin Thicke. This is where if we had really planned out audio, this is where
well, apparently it'd be inappropriate to play the two songs back to back for the purpose of this comparison.
I don't know what that says. It's very unique. Well, I mean, the judge is saying that for much different reasons, because he doesn't want prejudice jury, if there's copyright on the sound recording. Anyways, that's kind of step 6 and 7. Um,
Aw.
so for those of you who haven't been following, Marvin Gaye's family has sought money from the Blurred Lines people. It's a
Robin Thicke and Pharrell Williams.
exactly. And so, but with just 2 weeks to go before a scheduled trial, a number of pretrial rulings have resulted in Marvin Gaye's family wanting to file an interlocutory appeal, which basically is an appeal before trial on an issue that's been decided.
And for the record, interlocutory is one of my favorite legal words, because there's no way to roll that off the tongue. It's just it's impossible to say.
You want to sound really smart.
Yes, if you want to sound really smart, it is basically a $10 word for the concept of an appeal before a final verdict has been issued, basically.
Right. So to briefly recap, Williams and Thicke actually sued first, which is kind of counterintuitive to most people because they wrote the second song, right? So you would think that they were the ones being sued. This is actually a pretty common thing when you're about to be sued. It's a pretty astute legal move to sue first for something called a declaratory judgment, which is like asking to a judge to tell you whether you're infringing or not. And the reasons to do this is generally you want to either get to a particular court because you think that court will rule, it will tend to rule in your favor, or if you, let's say, know that the other team has got a really good local legal team based in Nashville, but you're in California and you don't want to go to Nashville, so you file in California. And so that's what happened here. So we have the two songs,
Mm-hmm.
And I think a layperson, when they would think that if we're going to figure out whether these two songs are similar or not, would be like, okay, we're going to listen to the sound recordings, right? We're gonna put one, and then we're going to put the other, and then the jury is going to decide. Well, no, unfortunately not. Basically, there's an issue about the protections afforded to sound recordings because this was a pre-72, and as we've mentioned before, there's really no blanket federal protection for sound recordings pre-72 and their public performance rights. And so the jury, according to the judge, won't be able to hear the actual recording of Marvin Gaye's, was it Let's Get It On, or am I
Got to Give It Up.
Got to Give It Up. They seem to be asking the same thing, though, those two songs. Yeah, so there's this question of, like, how do you explain to a jury what a song sounds like without playing the song? And so they've been going back and forth where it's like, well, you can't play the actual song, but you could play it on a piano so that they can hear the notes, but then it's the piano against the song, so is that the right way to do it?
Or do you have an edited version of the song, which what the latest ruling was? Okay, yeah, you digitally remove the vocals and other elements from the song.
Right, because are the vocals like relevant or are they protected? And so it's one of these really funny stories, and the Marvin Gaye people who claim that there will be devastating consequences in the copyright world. Who doesn't say this? If they
every ruling has devastating consequences. Haven't you learned that? It's devastating for someone at least.
Yeah, a lot of people really will try to object to evidence being introduced. Like, Your Honor, that's prejudicial to my client. And the general rule with evidence is that if the probative value is significantly outweighed by the prejudice to the client, it can be not allowed, which means, like, if something's not really that relevant to the case and it comes out that the defendant is a child molester or something like that, and that's the kind of thing that you don't let in because it's not really relevant. But one of those things is like, Your Honor, this is really prejudicial because we're going to lose the case if you let it in. It's like, no, sorry, that doesn't count. That's admissible. So that's another thing that they always tend to say.
The main reason the sound recording is not allowed in, my understanding, for Marvin Gaye is that they did not register the sound recording with the U.S. Copyright Office, which in the United States is required for jurisdiction over the sound recording. That's a jurisdictional issue as much as anything. And the result of that is the court can't and will not be able to hear anything about the copyright infringement claim against the sound recording. And that's where you're getting this prejudicial that this is not. And a lot of it apparently is only in the sound recording. A lot of the issues and a lot of the similarities are not found in the composition, including the way Marvin Gaye sings the song. A lot of the backup vocals, etc., are not written in the composition.
Right.
So that produces a very serious problem. And what the Gaye estate is trying to say is that, well, basically the sound recording is an extension of the composition, and therefore it should be protected through the registration and things we have done for that. The protection for the sound recording should follow naturally. But Williams and Thicke are going, nuh-uh, or whatever the legal term for that is, and saying, the law is what it is. It may not, be perfect, but it's also not unfair. You have the same rights as everyone else in this position, type thing.
Right.
So it's a bizarre case, and it centers largely around, as you mentioned, the pre-1972 sound recordings and this idea that prior to then, sound recordings were protected under state copyright, which sounds
right.
State misappropriation, but
and in this case, you correctly were bringing up the registrations. That was required. You needed publication and registration sort of in order to gain copyright rights in your creative works. And so this is one of these weird hybrid areas where before the 76 Act, which had a later date of 1978 for certain derivative works which are made based off of works done before 78. It's definitely a complex reason why the evidentiary ruling ended up how it is. But at the end of the day, we have to end up with this ruling on whether a similar version can be shown to this jury. And so that's what the main current crisis is. And
whatever happened to the days in which musicians would just buy off people that accused them of plagiarism? Oh wait, we're getting to that. Oh wait, never mind. I'm getting ahead of myself.
Sure.
But and the issue of pre-1972 music actually comes up again in this next story, though, with Sony and Google. So it seems like a natural extension. Sony, Google, Apple, and others, including Groove Shark, because Groove Shark just needed a little more litigation against it. You know what Groove Shark needs? Another lawsuit. Yes, it needs another one. But anyways, they're being sued over their use of pre-1972 sound recordings in various radio-style apps. And long story short, they all run various radio services or music streaming services of different stripes. In Apple's case, for those playing along, that would be Beats that they bought out.
Right. This was the floodgates that I guess Sirius was warning of.
We should have seen coming.
Yep. Although an update at the end of the article did mention that only the lawsuit against Sony actually is still up there because a lot of the other companies were able to show that they did in fact license the pre-1972 works with catalog-wide licenses at the end of the article, which is good to hear,
Yeah. Which makes me ask the difficult question, what the hell, Sony?
Why are they the only one?
Why are you the only one sticking around?
Well, when we were talking about the global music rights lawsuit, a lot of these companies will buy these catalogs and they don't even know what's in them. They assume that they have all of these catalogs cover all of the music that they're going to play, but even Google doesn't know what they have the licenses for. And then they mention that in their GMR lawsuit. But yeah, so we're hit with this pre-72 music lawsuit. This happened because when Congress amended the copyright laws in the 1970s to cover sound recordings, protected only those authored after February 15th, 1972 under federal law.
Congress. Punting on issues since at least the 70s.
Yeah. Well, since then, a variety of music, users, including TV broadcasters, radio, DJs, bars, restaurants, they have performed pre-1972 sound recordings without really much legal trouble because it's been in this gray area. And we had this suit settle between Sirius, not settle, but it was ruled on between Sirius and the Turtles that there is in fact some state
Performance, yeah.
sound recording public performance rights for sound recordings in a few states, and so
You
now
only
you
need
have someone else
one.
trying to jump on that bandwagon.
You only need one.
You
Because
only
most of these things operate nationally, so if just one state rules there's a performance rights there, yeah, the floodgates do open. And in this case, the Flying Burrito Brothers, Hot Tuna, and the new writers of the Purple Sage. Those sound like band names I made up.
Yeah,
I did not make those up.
Flying Burrito. I can't even say the name. Flying Burrito. The Flying Burrito Brothers actually were mentioned in the Eagles documentary, the three, which was fabulous, by the way. The Eagles documentary about the band, and they were talking about the formation of the band. They were like, yeah, we really wanted this guy. He was playing with the Flying Burrito Brothers at the time, so he wasn't really interested in us, the Eagles. And I was just like, damn, dude, you chose the wrong horse. you know.
Oh,
Uh,
well.
oh well, indeed.
You know, I bet he still kicks himself a little bit every morning when he wakes up. Dude, I could have been in the Eagles. But it still worked out for me. Got to be a litigant in this lawsuit. But yeah, it's fascinating to see how this has been shaking out, though. And as you mentioned, the floodgates at least partially opened on this. But I think they went for a home run here, and it sounds like it was a swing and a miss for most of these guys. At least we'll see if Sony eventually gets dropped. But it's fascinating because there are thousands of other potential defendants of this.
Right,
This doesn't end with Apple.
Yeah, this could be major bad news, and then maybe a few more paydays for the pre-72 musicians, which these days are the only ones who can make money anyways, touring. So yeah, it's definitely spurred, as the article mentions, furious new lobbying attempts to get Congress to address pre-72 music.
Good luck with that.
But yeah, in the meantime, these lawsuits are still on their very early stages.
Let me ask you the question, putting Evan Shares on the spot here. What do you think should be done with pre-1972 music?
Oh man.
No pressure or anything. Just I expect a perfect answer in the next 2 minutes.
I personally think that that we should have a compulsory license system for these pre-72 music.
Okay.
It's just because it's been done for such a long time. I personally, as a listener, don't want them taken off the air. I do love my 60s music, so from a purely selfish point of view, if there could be some sort of compulsory license system in which various streaming and public performance software can pay a preset amount to have these songs played, I'd appreciate that personally.
Yeah.
I don't want them going away because I really appreciate them.
Do you think they should bring them underneath federal protection? I guess I would have to in order to install a compulsory license system. But of course that creates another problem because what we mentioned with the Blurred Lines lawsuit and this idea of copyright registration. None of these works were registered. Why would they be? There was no point in registering them, the the U.S. Copyright Office. So yeah, that produces an issue. Now you got two classes of work when it comes to registration, and this is the type of thorny stuff. But yeah, I agree with you that something should be done here, but I think along with this, maybe we should take the time to reevaluate the very bizarre copyright registration rules we have in this country.
Very bizarre. Agreed.
Very, very bizarre.
Also, if we're going with what I want, let's make a copyright registration a prerequisite for creativity, so that everyone needs to use my legal services.
Oh, there you go. Like a license. So you could literally get a poetic license.
Yeah, I guess you could.
Yeah, it'd be you'd be literally getting a creative license. All right, CSAC.
CSAC.
Tell me about it. I want to hear about this.
CSAC wants final approval on a $58.5 million settlement with TV stations.
Not often hear those words, especially when the settlement's going against them.
Right. So, they're a performance rights organization that dealt with local TV stations and their ability to syndicate shows. And so, as you know, most quality television shows have great soundtracks. And whether it's a song for a few seconds or, you know, for a whole minute, you basically have these television shows playing music, and that needs to be licensed. You need a syndication license. And so what CSAC had been doing, which is a great example of why ASCAP and BMI are under antitrust consent agreements,
Yeah.
is that they weren't making individual songs available for licensing. So if you had 30 songs in your, you know, season of Friends that you wanted to syndicate, and you went to CSAC and you were like, hey, I want to, you know, do this, CSAC's like, oh, great, you have to buy our whole catalog or nothing at all. It's kind of like the cable companies and their bundles.
Only worse, somehow.
And so, you know, it essentially was a minor form of monopoly, you know, and because they couldn't go anywhere else because of the they were in charge of these performance rights. And so probably the songs that are on Friends are not the right ones. These are probably more minor and lesser-known songs if it's CSAC handling them. So yeah, they got sued, and basically after 5 years of litigations, they've reached a deal, and there's going to be $59 million in damages paid out to, like this, including $16 million in attorney's fees and expenses.
Of course.
Which will go to affiliates of ABC, CBS, and NBC.
And this is obviously a move, though, to avoid getting hit with their own antitrust and their own consent decree, because this also requires them to offer alternative licenses and to offer the ability to work directly with the artists.
That's
basically
right.
not lock in the artists. They can only be licensed through CSAC. So yeah, this is obviously an attempt to avoid what happened to BMI and ASCAP, which is kind of the whole benefit of CSAC and now Global Music Rights to a degree, is that, hey, we don't have these consent decrees. We can charge more. We can give you more.
Right,
That's
and
kind of the whole
at
benefit.
the same time, it's supposed to result in more competition to bring down the prices. So
Yeah.
that hasn't come yet.
But real fast, speaking of music and TV shows, have you watched the TV show Stalker?
I haven't.
I'm not much of a TV person, but I've caught a few episodes of that, and they play like really, like they take music like, you know, that sounds kind of stalkery and do these very slow, creepy covers of them. It's really, really cool. So it's worth checking out for the music alone, I think. They usually play them at the end if you are curious about that.
I just actually got into Sherlock. I just watched the first
God.
episode last night.
How's that?
Amazing. First
Yeah.
episode really grips you. So that's my recommendation to you. The other one, Stomper, is the content. Is it good? Is it a good show? What do you think?
It's all right. It's not my cup of tea. It's a police procedural at the end of the day to me.
Okay.
But it's about stalkers. I mean, to me, all police procedurals are about the same, including CSI New Orleans, which really is very interesting with its handling of my city. But c'est la vie.
Yeah. So as part of the deal, in order to avoid this probably decree, they've essentially agreed that for the next 20 years, it will be obligated to offer alternatives to its blanket licenses, barred from preventing affiliated composers and publishers from entering into direct licenses with local stations, and prevented from threatening local stations with copyright infringement lawsuits during license negotiations. So they got hit with the they got hit with something here. You know, this is not maybe a consent decree, but it's close.
Yeah, and well, the main thing they avoid is the rate court system, which is what ASCAP and BMI, if you go to license from them and you don't like the terms they offer, basically they have to license you to work while you hash it out.
Yeah.
And then if you just can't work out the terms, it goes to an actual specialized rate court with actual specialized judges and stuff to actually settle what your rate should be with them. So ASCAP and BMI still have it worse, but yeah, only marginally so.
Right. So speaking of having it bad, the Beastie Boys
oh God.
and their $1.7 million copyright win wasn't really a win, we find out, because they have a $2.4 million legal bill. And, you know, here I am. Frozen dinners.
If you're watching the video, you are missing Evan actually foaming at the mouth a little bit about this.
Well, yeah. So the video is used for 5 weeks, which can show you like why we need a small claims court. Maybe this wasn't the perfect, one for the small claims court, but it just goes to show how fast, legal fees get out of control. 5 weeks of their songs being used by Monster, and the Beastie Boys have basically alleged that litigation tactics and non-good faith negotiations, or negotiations in bad faith, is what I should have said, basically resulted in the skyrocketing of legal fees.
That is called that.
Yeah. Uh,
That's a non-good negotiation.
Non-good faith. So
non-good faith negotiation, yes.
I'm not quite as barbaric as non-good, but it's up there.
Yeah.
So yeah, copyright lawsuits give a pretty large leeway when it comes to judges and their ability to hand out legal fees. So I don't think they have no shot. But yeah, the Beastie Boys are alleging that they offered to negotiate a deal post-trial to curb, additional litigation costs in terms of this part itself, in terms of asking for more money in the legal fees. But Monster didn't respond to the offer. And as a result, they want to be awarded $2.38 million in legal fees, including $900,000 spent prior to trial and $1.28 million during trial and $200,000 post-cost trial through December.
Now, the Copyright Act does guarantee you the right, or does at least offer the possibility that the judge can award attorney's fees, reasonable attorney's fees.
Right, and it's a pretty wide open area of the law.
And it's kind of one of those deals where the winning side will go, well, our legal fees are this number way over here. And that side goes, but your legal fees should be something way the heck over here. And then the judge goes, okay, it's actually somewhere about here.
Well, that's step two, right? First, he has to decide if the conduct of the parties necessitates the awarding of attorney's fees, and then once that's been done, they have to submit their attorney's fees, and then those attorney's fees are evaluated by your attorneys to cost you more money, and they'll say that these are unreasonable attorney's fees. You actually only should have charged this, which is parting through billable hours, which is such a nightmare. And that's step two, is to figure out what the actual number is.
Yeah, and that's the mess of this all, really, is that at the end of the day, you have the judge deciding what the attorney should be paid. And it's based upon, like you said, what evidence they can bring, what both sides believe is fair, and what the judge had for breakfast that morning could play a role. I mean, it really could be almost anything. But it does show. I think people, the 2.4 million strikes me as high, but not like, well, that's impossible. That is impossible.
I really don't know, but I don't really put many figures outside of what is reasonably possible as an attorney. Sometimes you get a pretty simple issue, and then 18 hours later, what seems like a simple answer actually really needed all that research, because not only are you doing all the research for all the documents that you're going to be putting in front of the judge, but you have to kind of rule out 7 other things, and so what you see on paper doesn't actually reflect what the work that a reasonable and competent and professional attorney has to do.
Yeah, I agree. And you also have the issue of, we don't know the details of the strategies both sides used. That one side or the other tried, like I said, they accused Monster of engaging in delaying tactics and sort of tactics designed to bury them in paperwork. If that's going on, the legal bills skyrocket, even at the time of the trial doesn't, expand much.
Right.
It doesn't take that long time-wise to get through it. It could be a very dense period of work because they had to respond to 80,000 different motions and other filings.
Yeah, I don't think the number is that unreasonable. I'd also like to quickly say hello to my friend Aaron, who is the CEO of Project Candy Box, who's listening to the show right now, and blowing up my phone here. He has a really cool service. Basically, it's a subscription-based service where they'll send you candy from different parts of the world that you don't know what you're going to get, but you get a new box every month. And so he's been doing really well up in Canada with that, and so he's listening to the show right now.
Oh, well, glad to have you here. What's the domain of it? Do you know?
His domain. I can Google it really quickly.
I know.
The
I'm putting you on the
domain
spot.
is www.projectcandybox.com.
ProjectCandybox.com. Okay, I was trying to find it real fast so I could throw the plug out too. Candybox.com. I am going to see if I'm subscribing to that. That sounds oopsie. Well, I guess it'd help if it was not if I typed projectcandybox.com and not projectcandy.box.
Yeah.
Um,
I don't think you want to go to dot boxes. That might be a
don't
specialized
even. Nothing good can come out of that TLD. Of course, it probably now is one thanks to ICANN. But so a big controversy happened last week involving Sam Smith. He is a guy I was unaware of before this week. Apparently he's a UK soul singer is how he's described.
Mm-hmm.
And the American musician Tom Petty. Apparently the chorus between Sam Smith's Stay With Me and Tom Petty and the Heartbreakers' 1989 song I Won't Back Down bear what some consider to be an uncanny resemblance.
So we've actually here at the Copyright 2.0 show set up a potential audio playing of these two songs.
All right, go for it.
So let's see if this works out. I'm gonna remove the headphones here so you all can hear the music coming from my computer. First one that you're about to hear is "Won't Back Down." This is the chorus. So listen carefully.
Turned around, and I'll keep this world from dragging me down. Gonna stand my ground.
So that is Tom Petty's "I Won't Back Down." Now here is Sam Smith's "Stay With Me."
Guess it's true, I'm not good at all
Let me get
understand.
to the chorus quickly.
Oh, won't you stay with me? 'Cause you're all I need. This ain't love, it's clear to see. But darling, stay with me.
Is that, it's got that dun dun dun, won't, no, I won't back down, and this is "Stay With Me," so it's uncanny. I don't know, what did you think? Were you able to hear it? I don't know, maybe that wasn't like the
I was able to hear it, and I'd listened to it before, actually. There's a lot of great mashup videos, too, of it, if you want to check those out. And, yeah, it's very uncanny. But it appears that Tom Petty is not really accusing Sam Smith of, theft or, being a plagiarist or anything like that. He's saying that it was an accident, and he understands these things happen. And they basically came together and worked out a deal where Tom Petty is now added as gets basically a writing credit on the song and gets some royalties for it, though it's unclear if he's getting back royalties or just future royalties. That the deal's not disclosed. So it seems to be a very amicable resolution. But a lot of people are saying that the similarities are purely coincidence or just the nature of music. And others are going, "Oh my God, Sam Smith, how could you dare rip off the great Tom Petty? I am rabble mad." So there's only two camps on this, and I kind of fall somewhere in between, personally.
Yeah, they came to an agreement. They're both credited with co-writers. I promise you he's getting back money. Even though I don't know that, but I know that. When it comes to copyright infringement, there's a few different camps in terms of different circuits and how exactly you prove it, but it's generally pretty close. You need access plus substantial similarity. When it comes to infringement. So he claims in the story, and at least reports, that I didn't know. He's like, I didn't know. I didn't copy it on purpose. This is just really one of those cases where two songs sound the same. So you need to show access. You need to show substantial similarity. But if you can show something called striking similarity, where independent creation basically is impossible because they're so damn similar, you don't actually need to show access. Although you can show access by showing how damn famous Tom Petty is, and even if you we can't show directly that you had his um, music sheet in your hands, we might be able to argue that we're so damn famous that like it's like a Rolling Stones song, you know, it's like a Beatles song. Everyone
Or
has access
Stairway
to
to
it
Heaven. I mean, come on, no one would sue over that.
because of its fame. Yeah, they could probably show that for Tom Petty, you know, but they don't have to because these songs are so close that I would argue that they're strikingly similar, which is a step above and beyond substantial similarity, and so that's why I think this settled so quickly. And
Yeah.
Good for Tom Petty, you know, for not
Backing down?
you know, doing the verve for not backing down. Not only not backing down, but not doing the Rolling Stones Bittersweet Symphony Take Everything, because they're
Yeah.
co-writers.
Yeah.
Yeah.
And we've seen this with other songs before. I mean, this is why Chuck Berry has a co-writing credit on Surfing USA, for example.
Mm-hmm.
It's a very
This is
similar situation
very
there.
common in the music industry. You know, sometimes you listen to a song a few days before and it's not even in your head consciously, but it's subconscious
And
inspiration. And you know, look at VH1 Storytellers. You have these musicians coming on all the time, being like, "Yeah, I was really inspired by like U2 when I wrote this song," and like they'll even come tell you.
There's actually a term for this. It's called cryptomnesia. You might it's when you think a memory or something you're creating is original when really it's a memory from something that you heard in the past.
I buy into that.
And cryptomnesia actually is pretty common. It's a pretty common plagiarism topic, but it usually stems to things like the song where you have a pretty simple chord progression and a general sound, but not necessarily like every single note of the song. You know, you have to be basically trying. There's a point where you have to be trying, and there's a point where you can remember something more unconsciously. It doesn't make it necessarily less of an infringement under copyright law, but it does mean that maybe he's not a hopeless jerk. You know what I mean? It could be a genuine accident, and this happens a lot in music, and it happens sometimes, and you see it in like with novels and so forth. Not so much the words in the novel, but the general plot arc sometimes can be the subject of this. So.
Yeah, and so I think this brings us to the last story of the day. Do you want to tell us about the magical utopia of Norway and their...
The magical utopia of Norway with its beautiful blonde women featured in the photograph on Music Worldwide.
Sweden?
Yeah.
Or maybe that's just all of Scandinavia.
I think it's all Scandinavia, honestly.
Yeah.
But remember, Finland is not in Scandinavia, technically. It's considered another geographic body. I learned that recently.
Did not know that.
It's actually because it's on the mainland with Russia. It's not actually on that weird little peninsula. It looks like it's eating Denmark. So,
well,
there you
listeners
go.
of the Copyright Ubuntu Show, if you're going to leave with anything today,
This geography lessons.
Finland is not part of Scandinavia,
Nope.
which to me is scandalous. But
it is. It is. But Norway has seen something of an extreme turnaround in the amount of music piracy it has seen. There's been an ongoing survey, as you might imagine, where they ask Norwegians under the age of 30, so technically I'm disqualified from this survey. Do you illegally download music? In 2009, 80% said yes, 20% said no. In 2014, 96% are now saying no, and only 4% are saying yes. And even though those 4% saying they are not getting it as their primary source of music, it's something that maybe they're just doing once in a while, I suppose. That is an extreme turnaround for illegal.
You know, I look at this
music.
and yeah, I think we're headed in this direction. But I also picture like, you know, a television camera and a microphone in front of a young a Norwegian, and be like, "Do you pirate the music?" And then they're looking up, "No," you know, like I just find it hard to believe. I'd have no reason whatsoever for you know commenting on their methods, because everything seems to be pretty well put together, and it's a good sign, and I hope it's true.
Now, what's interesting, though, is this has not led to a significant growth of the music market value in the country.
Right.
It's led to a significant growth of the digital value, because what's happening is these potential pirates are switching to legal streaming services, a la Spotify, etc.
A lot of which are free.
Yeah, and a lot of those are free. So the actual market value in 2009, according to this bar here on this bar graph on the site, was 592 million, whatever the hell the currency is in Norway, NOK, Norwegian kroner. I think it's kroner, Norwegian kroner. And in 2014, it was 601 million kroner. So that's an increase, but only about a percent, a little bit over a percentage point. That's pretty flat growth by any way you look at it. But then again, it hasn't shrunk either. So look at it that way.
I think slow, steady growth is a godsend for the music industry.
Right now,
So
anywhere.
they'll take it.
Yeah, we'll take any growth we see anywhere. So yeah, but it's still it's an interesting study, and it does seem, even if maybe I think maybe the results are a little exaggerated. Maybe it's not as low as the survey says. I do think there's been a significant turnaround because of these legal streaming alternatives. Now, like I said, the question remains: are these legal streaming alternatives significantly better than piracy? That's a debate for a different day. But at the end of the day, those illegally downloading music seems to have suffered a very, very sharp decline. I shouldn't say suffered, but has seen a very sharp decline.
Yeah, there's an interesting comment on the article from Lori Chilvers, and she says that Spotify is a success because it offers a user experience close to, if not indistinguishable from piracy. That is, you can have all the music you want in your back pocket. So on one end, the music industry is in effect celebrating the demise of piracy, while essentially offering what piracy did in the first place,
Yeah.
plus or minus some sleazy advertising, what she says. So it just goes to show you, though, that even though piracy may be going away, the little value there is in the streaming model is still going to probably take a long time before it really gets into the pockets of your middle-class artists.
I would agree with that.
You have a business model that is everything all the time, and the money coming into that is only as high as it as advertising revenue can pay, plus subscription fees, which isn't quite the same as what you can give in the old days. But the reality is that this is the only choice for the music industry. It's this or die. So hopefully, as more and more of the free to listen or short, small subscription fee business goes towards legitimate places like Spotify, as Spotify eats up piracy because it's a better service, then more money will eventually end up in the hands of the middle class artists.
I'm a Spotify user. I have a family plan, a paid plan.
Mm-hmm.
Everyone here is on it, and we love it. It's been great, and people ask me, well, what's so great about it? Well, it's basically like if you opened up iTunes and owned everything in iTunes. You've got all the things, and more or less all the things, and that's great. I mean, you don't have to think about what you own, where is it, what CD is it on. Oh, did I put that one on the computer? I forgot to rip that one. All that stuff. You don't think about that, and you don't think about, like, when I'm going for a run in the morning, I don't have to think, or all these songs on my phone, do I need to back them up? No, I'm just pulling it off the LTE network, or saving the playlist to the phone before I go head off. That's what the benefit is to me, is that convenience more than anything.
Oh yeah,
I'm
with you. I love the streaming service. I love the available offline service for Spotify, where you can just kind of like quasi download them on your phone. That's what I put on when I'm at the airport and I'm about to fly off on a plane. I put on my relaxing music. I didn't have to remember to put it and transfer it. I just make sure I have my Spotify app going, and
Well, we'll see if if Spotify and the rise of music, because there just comes a point though where if you're pirating music, you're just a jerk. At this stage of the game, with free Spotify and Pandora and all this other stuff, if you're pirating music, you're just a jerk at this point. You're a jerk who's working harder to be a jerk.
It is kind of harder to pirate music these days than to
obtain it legitimately. It really is. Yeah. So if you're pirating music in the United States, you're a jerk. End of story. Well, that's all the news I've got. You got any other thoughts on the past few weeks?
Not really. I don't think there's And other than to announce that I will be going to live band karaoke tomorrow at Hill Country Barbecue in DC. So if you want to, come and hang out and have a beer with me, that's where I'll be.
You got any plans on what you're singing? Any foreshadowing you can provide?
Oh, man, I'm not sure. I'm going to be meeting a cute intern there, so I've got a date. So it's definitely got to impress her. Obviously not my intern. That would be super.
that'd be Clinton-y.
Just happens to be an intern in DC, so it's got to be something that I could really rock. No, nothing too outside of my range. I once tried to do Dream On. That was kind of bad.
Yeah, don't
Last
do
time
anything. Nothing by Stones or by Queen. Those are the two first rules.
I'm trying. I think I might try something a little more contemporary. Or maybe I'll do like a Bon Jovi song. I think it's important that no matter what I choose, it has to be a crowd pleaser. Because even if then I'm not that good at it, if everyone kind of loves it, they can help me out.
Well, you could always sing Red Solo Cup. That seems all.
Not really a country guy.
Okay. Okay. Well, I have evidence that you were able to do Foo Fighters quite well, so there's evidence of that on YouTube, so you could always pick that up. Just a thought.
I know what, I'm going to get it recorded, and I'll stay tuned, kids, next week. If you come and listen to us again, you'll get 45 iPhone recorded seconds of me at live band karaoke.
And we will be getting back on our weekly schedule post-haste. Well, on that note, everyone, thank you very much for joining us. My name is Jonathan Bailey from the site Plagiarism Today, which can be found at plagiarismtoday.com, and I'm username Plagiarism Today on all the things, Facebook, Twitter, etc., ad infinitum.
And my name is Evan Sherris, and you can find me on Twitter at Evan Sherris, and we'll see you next week.
All right, well, thank you very much, and like I said, we will see you guys next week.